Great. So thank you. You can. Good afternoon, seniors. So Telfer will be taking you for the sixth session of interpretation. Thank you for joining the session, and sorry for the late start. Senior Telfer, you can take it away. Hi. Hello, please, am I audible? Telfer.
Then maybe you can write your own names and then maybe notice maybe I'm a director and you can make the other person a shareholder. So you write your own name to private director and write head to private shareholder.
Hello.
Yeah, hi, senior. You can start. We are recording the session.
Okay, but can you hear me, please? Please confirm if you can hear me.
Yes, please, I can hear you. I think the others can also confirm.
Thank you. Hi. I'm back. Yeah, can anybody please confirm if you can hear me? I'm speaking now.
Yeah, we can hear you.
Great. Sorry for the challenges. Good afternoon and welcome once again to these interpretation tutorial sessions organized by Mr. Fatah Mahama as part of your preparations for the impending Part 2 exam. Last week we began our discussion on ouster clauses, where we began to look generally at what they were, what their effects, or what the effect of ouster clauses are in respect of different categories of documents, and what the nuances in respect of the application pertains. And so we try to look at the introduction two ouster clauses where we outline that ouster clauses can be found in constitutional documents, private documents, or statutory documents. And then we looked at what the effect of the ouster clause is, which is essentially to limit or restrain, or for want of a better word, oust the jurisdiction of a court of competent jurisdiction otherwise from going into the claim. We did also recognize that even though the law allows for the application of ouster clauses or the use of ouster clauses in some instances, the supervisory jurisdiction of the High Court and the Supreme Court cannot necessarily be ousted in terms of whatever arrangements parties may have or whatever statute that has been enacted. And so, to that extent, we said that it was erroneous for anybody to suggest that there could ever be a situation where a court's jurisdiction is completely ousted, especially when it relates to statutory matters and private arrangements. And so, as the discussion went on, we concluded on the part relating to chieftaincy. And we said that today we'll spend our time looking at chieftaincy, which of the statutory ouster clauses that we have, and there are many, the one that is or that attracts the most attention in our interpretation class is the statutory clause relating to chieftaincy. And so that is what we'll spend a chunk of our time doing today. But before we proceed, if anybody has a question from any of our previous discussions, you may please bring it up now. I'll give about a minute window for that. In the absence of that, we'll proceed. So please, does anybody have a question, something that is bothering you, that you want us to clarify now? Okay, so let's proceed. Today we are looking at the concept of chieftaincy, and it is part of the discussion on ouster clauses. So please situate it in that context. It's very important that you have that at the back of your mind. Now, the 1992 Constitution of Ghana guarantees the institution of chieftaincy together with its traditional councils as established at custom. You have to recall that chieftaincy has always been an important part of our governance process, right from our colonial days down to our days with democracy and independence. And so, for instance, you would see in the case of Nana Ejiofor against the Attorney General and National House of Chiefs that advanced dictum where he noted that chieftaincy is a revered and constitutionally entrenched institution of Ghana, and that the reach of chiefs extends beyond the formal machinery of the Ghanaian state. And so the concept of chieftaincy has always been a part of us, and it is one of the most enduring institutions of our nation state that has subsisted arising out of, or that has subsisted throughout the entire eras that we've been through military regimes, through democracy, through the time that there was an attack on the institution of chieftaincy and everything. And so naturally, chieftaincy has always occupied an important place in our body politic and in our national life. And so in the 92 Constitution, we took a step under Article 277 to define who a chief is. And if somebody can please read Article 277 for us of the Constitution. If you have your Constitution, please read Article 277.
Article 277. It says, in this chapter, unless the context otherwise requires, chief means a person who, hailing from the appropriate family and lineage, has been validly nominated, elected or selected and installed, and skinned or installed as a chief or queen mother, in accordance with the relevant customary law and usage.
Great.
Done.
So he says the provision indicates to us that a person who hails from the appropriate family and has been nominated, elected, or selected, and validly installed and skinned or installed either as a chief or a queen mother is a chief within the contemplation of our 1992 Constitution. This is important because we are trying to distinguish or trying to understand what it means in respect of situations where we say a matter relating to chieftaincy has arisen. So keep this in mind as to what the definition of a chief is. And this same provision is repeated in Section 57 of the Chieftaincy Act 2008, Act 759. So it's important that we have that in mind, that for the purposes of everything we do in respect of our understanding of chieftaincy, it must relate to either a person as a chief or queen mother, and the said person must hail from the appropriate family, he must have been validly nominated, and then he must have been validly installed or enskinned as a chief or queen mother in accordance with the relevant customary law and usage of that particular community. Because as you know, every customary community in Ghana have their own customary law rules and usages or practices that determine the way in which persons are selected and installed as chiefs. And so if a person has gone through the appropriate process and has now risen to that level, then we can say that he has complied with the statutory provisions in terms of what the proper definition of a chief is. Please read Article 271.
Article 271. There shall be a national house of chiefs.
Mhm.
Should I continue?
Yes, please.
Okay, 2712. The House of Chiefs of each region shall elect as members of the National House of Chiefs 5 paramount chiefs from the region. 3. Where in a region there are fewer than 5 paramount chiefs, the House of Chiefs of the region shall elect such number of divisional chiefs as shall make up the required representation of the chiefs for the region.
So the 92 Constitution establishes 3 tiers of chieftaincy bodies, if you like, or it establishes 3 tiers of House of Chiefs. So there's the National House of Chiefs, which is referenced, or which provision she has just read for us, the Regional House of Chiefs, and the Traditional Councils. The National House of Chiefs, so now we would have to go to, so the composition of the National House of Chiefs is provided for in the Constitution and also in the Chieftaincy Act. So if we look at Section 1 of the Chieftaincy Act, if you may, please read just Section 1.1 for us from the Chieftaincy Act.
I don't have the Chieftaincy Act unless I check online.
Okay, so I would project it and then you read it for us.
Okay.
Please, can you see my screen?
Yes.
Okay, so please read Section 1.1 again as well.
Okay. Section 1.1. In accordance with Article 271 of the Constitution, the National House of Chiefs consists of 5 paramount chiefs from each region, elected by the Regional House of Chiefs, elected by the Regional House of each region.
So the Chieftaincy Act also affirms the composition of the National House of Chiefs. It tells us that every regional house shall elect from amongst its members 5 persons or 5 paramount chiefs, and then they would come together to form the National House of Chiefs. And the Act also further prescribes situations where there are fewer than 5 paramount chiefs in the region. It indicates that the House of Chiefs of that region are entitled to elect a number of divisional chiefs as shall make up the required representation of chiefs for the region. So that is the composition of the National House of Chiefs. Now let's go to the Regional House of Chiefs. Please read section 6.
Section 6. Section 6 of what, please?
The Chieftaincy Act. I believe it's on the screen.
Yes, okay. So section 6. Oh, sorry. In accordance with Article 274 of the Constitution, the Regional House of Chiefs consists of members specified by legislative instrument made by the National House of Chiefs and issued under the signature of the President of the National House of Chiefs. Should I continue?
No. So in terms of the Regional House, there's no specified number. The National House of Chiefs has been given the discretion to determine from time to time what exactly should be the number of the persons who sit in the Regional House. And the Regional House of Chiefs comprises of paramount chiefs in that particular region. So the paramount chiefs in that particular region come together to form the Regional House of Chiefs. Then read 12.
Section 12. There shall be a traditional council in each traditional area.
Skip to 13.
Okay, 13. The paramount chiefs of a traditional area, or in the case of the Kumasi traditional area, the Asantehene, shall be the president of the traditional council.
And so traditional councils are also set up by the Chieftaincy Act to allow for a situation of the 3 tiers I was telling you about: the National House, the Regional House, and the Traditional Council. So the Traditional Council is led by the paramount chief of the area, who sits in council with the sub-chiefs and the lower chiefs. And then there's the Regional House, which is made up of the paramount chiefs of the area. And then there's the National House, which is made up of chiefs selected from the Regional House, which every Regional House must nominate at least 5 persons. So this is the framework we are talking about in terms of the 3 tiers for the chieftaincy structure that we have. Yes, Joe, did you have a question?
Yes, please. Can you take me through the constituents of the regional and the traditional house, please?
Okay. So Regional House is made up of the paramount chiefs in the region, and the number is not fixed. So the chieftaincy, the National House of Chiefs, is given the power at law to make LIs that will determine the number of persons that should be at the Regional House of Chiefs. And I'm saying that the Traditional House of Chiefs, or the Traditional Council, sorry, is made up of the paramount chief of the area and his sub-chiefs and such other chiefs that will be pointed out. And then they come together to form the Traditional Council. In effect, the paramount chief is the de facto is the de jure and de facto leader of the Traditional Council. In the case of the Asantehene, he is also the president of the Kumasi Traditional Council. And these traditional councils have their particular responsibilities as outlined in the Chieftaincy Act, as to the Regional House and as to the National House. So this is the membership of the Traditional Council. So for instance, if you want membership of Traditional Council, you may see section 14 of the Chieftaincy Act. Are we okay?
Yes, please. Thank you.
Great. So moving on, having established the categories of House of Chiefs that we have, you have to recognize that the law also creates chieftaincy tribunals. So I want you to have this at the back of your mind, that anytime we are talking about the chieftaincy tribunals, we're not talking about the House of Chiefs per se. So it is wrong to say that a regional House of Chiefs or a national House of Chiefs or a traditional council has jurisdiction in any matter. That would be wrong. In the exercise of their judicial function, so the traditional councils, the National House and the Regional House all have judicial functions. in the exercise of their judicial functions, they are expected to act through their judicial committees. And so the traditional council exists, and the traditional council has a judicial committee. Same for national house, same for regional house. And that when we are dealing with causes or matters affecting chieftaincy, we mean that these are matters that are within the exclusive jurisdiction of the judicial committees and not the house per se. I hope this makes sense.
Yes, but please, does that mean not all the members of the National House of Chiefs will be part of the National Judicial Committee?
Absolutely.
Okay.
So not every member of the traditional council or the regional house or the national house will form part of the judicial committee. So let's go through the Chieftaincy Act again, and I'll share the screen. Please read section 22. So you'll see that please, scholars of interpretation, what is this called?
The heading.
So you see that it is titled, thank you. You see that it is titled Original Jurisdiction of the National House of Chiefs. So read 22.
22. The National House of Chiefs has original jurisdiction in a cause or matter affecting chieftaincy. A. Which lies within the competence of two or more regional houses. B. Which is not properly within the jurisdiction of a regional house. Or C. Which cannot be dealt with by a regional house.
Skip to 25.
25. Judicial Committee of the National House of Chiefs. 25.1. There shall be a Judicial Committee of the National House, which shall exercise the original and appellate jurisdiction conferred on the National House under this Act.
The point I'm trying to make to you is this, that the National House has been given jurisdiction in respect of causes or matters affecting chieftaincy in three categories. The first one is if it lies within the competence of two or more regional houses, or if a regional house of chiefs does not have the jurisdiction to deal with the matter, or three, the regional house is unable to deal with the matter. In that instance, the National House can exercise its original jurisdiction. In terms of appellate jurisdiction, if it's a cause or matter affecting chieftaincy that has been determined by a regional house, then the National House will have the ability to assume jurisdiction in terms of its appellate powers granted it by the law. The point I'm making is this, that even though the law has vested that power in the House, the law further clarifies that in exercise of such original or appellate jurisdiction, the House must exercise it through its judicial committee. And we'll go to the composition of the judicial committee shortly. But it must be emphasized that in the exercise of its judicial functions, the National House, Regional House, and Traditional Council must always act by judicial committee. Please, are you clear? Does this make sense, please?
Yes.
Beautiful. Let's proceed. Section 57 of the Courts Act outs the jurisdiction of all courts in Ghana, with the exception of the Supreme Court, in causes or matters affecting chieftaincy. It indicates that, subject to the Constitution, no court other than the Supreme Court may exercise original or appellate jurisdiction in any cause or matter affecting chieftaincy. So what is a cause or matter affecting chieftaincy? Let's go to section 76 of the Chieftaincy Act. I will share it with you shortly. Can you please read this for me?
Section 76. Do you want me to read just the highlighted portion?
Yes, please.
Okay. So, cause or matter affecting chieftaincy means a cause, matter, question, or dispute relating to any of the following: the nomination, election, selection, or installation of a person as a chief, or the claim of a person to be nominated, elected, selected, or installed as a chief. B. The deposition or abdication of a chief. C. The right of a person to take part in the nomination, election, selection, or installation of a person as a chief, or in the deposition of a chief. D. The recovery or delivery of stolen property in connection with the nomination, election, selection, installation, deposition, or abdication of a chief. And E. The constitutional relations and the customary law between chiefs.
Okay. So section 76, which has been reproduced, or which is similar to the provision you find in section 117 of the Courts Act. So we're dealing with two provisions here. First, section 57 outs the jurisdiction of all the courts in Ghana except the Supreme Court in causes or matters affecting chieftaincy. And section 117 of that same Courts Act explains or defines what a cause or matter affecting chieftaincy is. And that provision is similar to the one you see in section 76 of the Chieftaincy Act. That indicates that a cause or matter affecting chieftaincy is defined as, and those five things that was just read out to us. So we'll come back to that shortly. Like I mentioned last time, there are two schools of thought, or there had been two schools of thought in respect of the power of the statutes, i.e., the Chieftaincy Act and the Court Act, to oust the jurisdiction of the courts in causes or matter affecting chieftaincy. In fact, one school of thought believed strongly that such an action was inconsistent with the provisions of the Constitution, and that those provisions were unconstitutional, if you like. The argument is this, that, one second, please. Apologies for the break. So, like I mentioned, the question has been whether the High Court should have concurrent original jurisdiction with the chieftaincy tribunals. And I've mentioned what the chieftaincy tribunals are: the judicial committees of the traditional council, the regional house, and the national house. And so the determination or the question was the constitutionality of Section 57, read together with the provisions in the Chieftaincy Act that operate to oust the jurisdiction of the High Court in causes or matters affecting chieftaincy. And I said that the first, those on one side, those who believe that the provisions are unconstitutional, indicates that the Section 57 conflicts with Article 141 in terms of the jurisdiction of the High Court. So please read Article 141.
Article 141, it says, the High Court shall, subject to the provisions of this Constitution, have jurisdiction in all matters, and in particular, in civil and criminal matters, and such original, appellate, and other jurisdiction as may be conferred on it by this Constitution or any other law.
A plain reading of the provision indicates that the Constitution has said that the High Court has jurisdiction in all matters, and that that provision is only subject to some other provisions in the Constitution. Sorry. So, for instance, the Constitution limits or outs the jurisdiction of the High Court in terms of matters relating to the interpretation or enforcement of the 92 Constitution itself. And so the implication should be that, or the understanding should be that any limitation on the jurisdiction of the High Court in any matter should have been provided for by the 1992 Constitution itself, and that any other limitation or restriction that is set out in some other statute would be inconsistent with the provisions of the Constitution. And so those who argue that the High Court does not have jurisdiction in chieftaincy matters would have to point out to us the provision of the Constitution that intended, or that showed that the framers intended to oust the jurisdiction of the High Court in relation to chieftaincy matters. That is one school of thought, notably expressed by Kluge and E.D. Combe, right? On the other hand, the other school of thought is that there's no conflict between Section 57 and the provisions of Article 141 of the Constitution, and that is the current position of the law. In their view, or in the view of what the Supreme Court has now adopted to be the correct interpretation of the law, it says that it is to the effect simply that, and let me explain. Article 141 does not necessarily give the High Court original jurisdiction in all civil and criminal matters. It is to the effect that the expression jurisdiction in all matters refers generally to the general jurisdiction of the High Court, as contrasted with the other jurisdictions that the High Court has, such as original, supervisory, appellate, and review. And that each of these jurisdictions can be conferred on the High Court by the Constitution or any other law. And that is why in 141, the provision says such original, appellate, and other jurisdiction as may be conferred by the Constitution or any other law. And so the true effect you would see in the provision is that by virtue of Article 1255 of the Constitution and 141, the legislature has the power to apportion jurisdiction in all civil and criminal matters among the superior and inferior courts, except the ones expressly outlined in the Constitution itself. What it cannot do is to take away jurisdiction expressly outlined in the Constitution itself. For instance, it cannot operate to oust the jurisdiction of the High Court in a matter in relation to the trial of a person or who has been alleged to have committed treason or high treason. And so the current position of the law is that the High Court's jurisdiction in relation to causes or matters affecting chieftaincy has been ousted. Of course, subject to the discussion we are going to have much later. But that the correct position that we should understand is that there's no concurrent jurisdiction. The High Court does not share, or the chieftaincy tribunals do not share their jurisdiction in terms of chieftaincy matters with the High Court, and that it is okay for the legislator to have prescribed that an exclusive situation will arise for the chieftaincy tribunals when it relates to a cause or matter affecting chieftaincy. So those are the two schools of thought, and that is how we've come to the current position that we assume under the law. Having mentioned that, it is important to outline what a trajectory has been in respect of our understanding of the exclusive jurisdiction of the chieftaincy tribunals. Now, in Toba and Kwekuma, I'm sure this is a case you have heard about and you are familiar with. This was a matter that was brought before the High Court for a declaration that the defendants at the time had no right to nominate or appoint or install any candidate as a chief of the Agona division without the consent of the plaintiffs. So they obtained judgments in default based on the terms they prayed for, and the defendants, by motion or notice, applied to the court to set aside the default judgment. They contended that because the matter was before the High Court was a cause or matter affecting chieftaincy, the High Court was not the proper forum to determine the action. And in any case, that same matter was already pending before the Judicial Committee of the Ahanta Traditional Council at the instance of the same plaintiffs. And so the court was called on to make a determination. Now, the High Court judge ruled that the High Court does not have jurisdiction to entertain a chieftaincy matter at first instance. One second, please. So, dial back, 1 second. So the High Court judge, when called to make a determination, held that there was a tension between sections 14(1)(a) and 52 of the then Courts Act, which established that the High Court did not have jurisdiction to entertain a chieftaincy matter, and that under section 14(1)(a), the High Court had original jurisdiction in all matters. And so, as a result, that High Court was seized with jurisdiction to hear the claim and the allegation made by the defendants in terms of the lack of jurisdiction of the High Court was improper. Now, when the matter went on appeal, the judgment was set aside, and the court held that based on the Chieftaincy Act, the Traditional Council had been clothed with exclusive jurisdiction to hear and determine any cause or matter affecting chieftaincy arising within the area, and that the understanding that ought to be gleaned from the provisions of the Courts Act and the Chieftaincy Act is that the jurisdiction of the High Court in all matters, civil or criminal, does not extend to chieftaincy matters because legislation has expressly provided for same. And so Toba and Kwekuma outlined the position that currently pertains in Ghana, that when it comes to causes or matters affecting chieftaincy, even though the High Court has jurisdiction so broad in all matters civil and criminal, in relation to causes or matters affecting chieftaincy, the High Court has no say and cannot assume jurisdiction over the matter. Now, prior to the decision in Toba and Kwekuma, the High Court, or two different High Courts in Ex parte, Edu Jemfi and Mosi and Boating, had ruled that the High Court had concurrent jurisdiction with the Traditional Councils and the Regional House of Chiefs, such that in a cause or matter affecting chieftaincy, you could either go with the Traditional Council or the Regional House, or you may decide to go with the High Court. And because it shared that jurisdiction or had concurrent jurisdiction with those tribunals, it was not wrong for you to have initiated action in the High Court. But Toba and Kwekuma laid down the correct position we apply currently and clarified that the High Court does not have concurrent jurisdiction with the chieftaincy tribunals, and that the jurisdiction vested in the chieftaincy tribunals is exclusive and same, that is not shared with any court in its original or appellate form, depending on the nature of the claim. Please, is this clear?
Could you take the last part again, please?
So the position is that if it's a cause or matter affecting chieftaincy, i.e., if it comes within the contemplation of Section 76 of the Chieftaincy Act, those matters enumerated from 1 to 5 or A to E, then the High Court does not have any jurisdiction, and no court, of course, with the exception of the Supreme Court, as we've clarified, does not have any jurisdiction in relation to the matter, and that it is the exclusive preserve of the chieftaincy tribunals, depending on the nature of the claim, that can determine that cause or matter affecting chieftaincy. And so any attempt to initiate those actions, whether in the original or appellate form in the High Court or the Court of Appeal, would be unlawful and in contravention with the Courts Act and the Chieftaincy Act.
Okay.
Okay, so you may also see the case of ex parte.
I
Yes,
have
yes.
one
Go,
question.
go
So,
ahead.
which you mentioned the case that they said it was held that both the traditional council and the High Court had concurrent jurisdiction.
Ex parte edu jemfi.
Okay.
Republic
Thank you.
Party, ex parte edu jemfi.
Thank you.
Great. So you may also see the case of Republic versus High Court Denu ex parte Avadili IV, where the Supreme Court clarified that the High Court has no jurisdiction to entertain a cause or matter as a court of first instance. Ex parte Avadili IV. And also, you may see the case of Nungwa Chieftaincy Affairs, Nungwa Chieftaincy Affairs, Odai Ayiku IV against Attorney General, Odai Ayiku IV against Attorney General, Bokete Lawe the 14th, Bokete Lawe the 14th applicant. Bokete the 4th, Bokete Lawe the 14th applicant. And so now that we've mentioned that the High Court has no jurisdiction to deal with causes or matters affecting chieftaincy, we can go back to Section 76 and look at them one after the other. Now, Section 76 is to the effect that a cause or matter affecting chieftaincy means a cause, matter, question, or dispute relating to one, the nomination, election, selection, or installation of a person as chief, or the claim of a person to be nominated, elected, selected, or installed as a chief. And so if there's a dispute relating to the nomination of a person as chief, the election of a person as chief, the installation of a person as chief, it is a cause or matter affecting chieftaincy. But it doesn't stop there. If a person claims to have the birthright or to have a valid claim to the throne, and maybe the person is being sidestepped, then the person can also bring an action, and in that instance, that will constitute a cause or matter affecting chieftaincy. For this one, you may see the case of Riwenchi Stool Affairs. Riwenchi Stool Affairs. The next one is the deposition or abdication of.
Hello. Can you please
Yes.
take your time a bit? We are trying to write. Thank you.
Which part of what I said did you miss?
I got it, but I'm trying to write as you go so I don't miss.
Hi, I didn't get it. Can you please start numbering again?
Okay, so number one, I'm saying there are 5 instances where a cause or matter affecting chieftaincy will arise, according to Section 76. The first one is if it relates to the nomination, election, selection, or installation of a person as chief. So if any dispute arises or any something happens in the process of nominating a person as a chief, in the process of installing a person as a chief, you are alleging there's some irregularity or something went wrong, then you can bring an action, and that action will be constituted or be seen as a cause or matter affecting chieftaincy. Then, in that same vein, if a person has a claim to be nominated, installed, elected, or selected as chief, and say, for instance, that claim is sidestepped to his detriment, especially when he has not, we are not in a situation where the person has said, I have no interest in having the stool, then that would be a situation where a cause or matter affecting chieftaincy has arisen, and the person can then bring an action before the chieftaincy tribunal, depending on what the matter relates to. Then the next one, so number 2, is the deposition or abdication of a chief. Deposition means the removal. Abdication means the voluntary resignation. And so if there's any question relating to the removal of a person as chief or the voluntary resignation of a person as a chief, or by some other act, that act will be constituted or be seen as an abdicating act, then you may bring an action as a cause or matter affecting chieftains. Because there are instances where some customary communities believe that a person conducting himself in a certain manner will be viewed as he abdicating. And when that happens, the chief may contest or dispute that he has not abdicated the stool. And so when that dispute arises, that will be a cause or matter affecting chieftaincy. You may see the case of Boampong and Abuaje. Boampong and Abuaje. Boampong is spelled Boampong, and Abuaje. 3, the right of a person to take part in the nomination, election, selection, or installation of a person as a chief, or in the deposition of a chief. Remember the first 2. The first one relates to the nomination of a person as a chief. The second one relates to the deposition of a person as a chief. The third one is that there are individuals or parties in the customary community that are entitled to take part in A and B. So C is that you may have a right to take part in A and B, and that right may have been sidestepped, or the appropriate procedure was not followed in sidestepping your rights as well. And so if you are challenging that, or you are bringing an action to the extent that that has occurred, and you are trying to vindicate, or you are trying to ensure that you get justice for the sidestepping of your rights, that will be a cause or matter affecting chieftaincy. So I'm an elder in the community. I'm entitled to participate in the installation of a chief or the deposition of a chief. And a chief was installed or deposed without my participation, then I can bring an action, and that action will be considered as a cause or matter affecting chieftaincy. Can I proceed?
Yes.
Number 4, the recovery or delivery of stool property in connection with the nomination, election, selection, installation, deposition, or abdication of a chief. What this means, or what this relates to, is that in respect of A and B, there are certain stool property that a person may come to, or a person may be entitled to. So when you become chief, some stool property will be vested in you. And when you are leaving office, you are expected to return the property, especially when you have been deposed or you have abdicated. And so if there's any dispute in relation to the delivery of the property or the recovery of that property, then we can bring an action in terms of a cause or matter affecting chieftaincy. And so for that, you may see the case of Enin and Abebil. Just pause on that point. So, set of facts, hypothetical set of facts. A person is alleged to have stolen stool property. He has been charged by the police, brought before the circuit court for a criminal trial, files a preliminary legal objection and says that because it relates to stool property, it is a cause or matter affecting chieftaincy, and so the court does not have any jurisdiction. What do you think?
Please, the question again.
So I'm saying that a person is alleged to have stolen stool property. Let's say the golden stool. He has stolen the golden stool. And he has been charged. And when he was charged and brought before the circuit court for a criminal trial, he filed, or his lawyers filed, an objection and indicated that the circuit court has no jurisdiction because the matter was one that is a cause or matter affecting chieftaincy. And as a result, the jurisdiction of the circuit court has been ousted. What do you think?
All right, thank you. I want to share an opinion. I think it is a basic question that is not a cause or matter affecting chieftaincy because as my sister has enumerated in the 5 instances you have given us, a cause or matter affecting chieftaincy does not include an outsider who has stolen stool property, even though the property that is said to have been stolen has the character of stool property. And so this the filing of the counsel of the accused person will not hold because the matter in respect of which they are in court is a matter in respect of theft, stealing, simplicity, and nothing to do with the chieftaincy issues. This is my basic understanding of the question.
Any other views, please?
And I also think that, just to add a little, the person is not even a chief, and it has to be related to someone who is a chief or queen mother.
Okay.
And this is also a criminal issue. So
let's give it another say for instance, the person is a chief, right? And the person he's still in office, but he's alleged to have stolen stool property. Is it a cause or matter affecting chieftaincy?
Yes.
no, please. Oh,
Who says yes? Who says no? Yes,
I
tell
thought
us what.
yes. Because I mean, a clear reading of section 117 says this recovery of stool property by virtue of one being appointed or removed as a chief. So once you've been appointed as a chief, you are a chief. So if we need you to bring some properties to us because we think you've stolen it, it's in order. It's a chieftaincy matter that cannot go to court. And also if you are not, but this one, he is sitting, he's still a chief. So if you are in power and we think you've stolen something, I think the right forum will be the chieftaincy tribunal and not the court, but it's just an opinion. I think that's what the 1171D says.
Okay, Abna, let's hear you. You said yes, or you said no, actually.
no. In fact, I've changed my mind. Yes, because
Really?
the person is chief. Yeah, and okay. What I was also looking at is the fact that it's a criminal. It's a criminal issue, but looking at the fact that it has to do with the person is a chief, and it's also a cause of matter affecting chieftaincy. So,
But you see, my question, you see, let's go back to 117 and section 76. It says that the recovery of the property in connection, there's a nexus, in connection with the nomination, election, selection, installation, deposition, or abdication of a chief. My question was on the premise that the dispute doesn't relate to his nomination, the dispute relates to his deposition. He's holding the property as chief. No question has arisen as to whether he was validly nominated. No question has arisen as to whether he has been deposed or he has abdicated as a chief. Would you then say that that allegation of stealing stool property is a cause or matter affecting chieftaincy?
In fact, it's not.
I don't know if I don't understand the question, but is your question that a chief has stolen stool property and they are requiring him to return it?
Yes.
Or I don't
In
understand
fact,
section 1171D.
It's not because it is not a cause or matter affecting chieftaincy. It doesn't have to do with all the points that we just went through as to the nomination, election, selection, and installation of a chief. It doesn't have to do with the deposition and abdication of the chief, and it also doesn't have to do with the recovery of stool property or delivery of stool property in connection with the nomination, election, and selection. There's nothing in issue about the nomination, election, selection, installation, and deposition or abdication of the chief. This is purely a chief going to steal a stool property.
But
Okay,
how
so
would he have gotten access to the chief stool property if he has not yet been nominated or appointed?
he's chief.
Aside the stealing aspect.
No, so Jody, I'll clarify your
Okay.
hold on, just hold on for me.
You know,
Oliver,
okay.
hold on.
Okay.
Just so we are not chaotic. Oliver, let me hear you.
Yeah, so I was thinking the stillment is also part of a matter affecting chieftaincy. So if a chief has gone ahead to steal, definitely at the end of the day, he will be the stool. So it's a matter affecting chieftaincy. That's my thinking. I don't know if I'm right.
I guess where you're coming from, but hold on to that thought. Stephanie, let's hear you.
This is a brief question. By section 117D, do you mean section 76D?
Yes, 76D of the chieftaincy.
Okay, so there's nothing like 117D.
Okay, thank you. Okay, Nanajwa, let's hear you.
Is my mic on? Yeah, so I think that I was just trying to clarify the confusion in Sally's mind. So when it comes to the stealing of a property or a stolen property, relating it to your question, it is supposed to be connected to the nomination, appointment, disposition, or election of a chief or a queen mother. So the question Telfer posed said that a chief who has stolen, he didn't make mention of whether he was going to be disposed or something. So it has got nothing. It is not a matter affecting chieftaincy. It's way no than criminal offense and accident. Yeah.
Stephanie, again, did you say there's no 117?
Asking if there is something like 117.
Yes.
Oh, I'm reading from the Court Act. Sorry.
From the Court Act.
Is in,
okay.
Yes, the Court Act.
Okay, thank you.
The Court Act 1171D is what we are talking about, and it's the same as section 76.
Okay. Thank you for the clarification.
You're welcome. Anybody else wants to add any? This is a very exciting discussion. Any perspective? I guess the point I'm trying to make to you, and Nanajwa helps with the clarification, and Abena as well, is that there has to be some connection with either the nomination or the deposition or abdication in relation to the stool property. That is when we'll say it's a cause or matter affecting chieftaincy. If there is no connection, it will be difficult for anybody to say that's a cause of matter affecting chieftaincy. So please see the cases of Eni and Abebio and Republic versus Court of Appeal, ex parte Ekuntan. See, it's spelled Ekuntan. Please, did you get the cases?
Yes. Republic versus Court of Appeal, ex parte Ekunta, right?
Yes, Ekuntan.
And Ekuntan. Then Enin versus Abebio.
Yes, please. Then number 4. Number 5. It says that the constitutional relations and the customary law between chiefs. The constitutional relations and the customary law between chiefs. Does anybody know what this means? Does anybody know what this means?
Hands are raised, please.
Okay, Richard, let's hear you first.
All right. How I understand this is the customary relations between a chief of a higher rank and some other chief, especially in respect of which of the chiefs pay homage to the other one. And in terms of rank and the chieftaincy, their chieftaincy titles, which of them will be higher than the other one? I think basically that is what I understand the constitutional relations and customary law between them. I don't have the acts here, so this is how I understand it.
Okay. Somebody else. Oliver, you had your hand up as well. Oh. Okay, Mark P, please. I hope I'm mentioning it correctly.
Yeah, so to add to what Senior Richard just said, I think it's about allegiance, that among two chiefs or within a traditional setting, who is to hold allegiance to who. And I think a typical case is about the one of Otumfuo and then some chiefs in Brunaf region, that as to whether they are supposed to hold allegiance to the Sunyani Manhene, or they are supposed to hold allegiance to Asante Hene. So I think for that provision, it's about allegiance. Thank you.
Okay. Anybody else?
Telfer, can you please repeat the provision in question?
It says that, so let me read. Cause or matter affecting chieftaincy means any cause, matter, question, or dispute relating to any of the following. And now we're on number 5. The constitutional relations and the customary law between chiefs.
Okay, so how does the relationship between that Santehene and Desniani chiefs come in?
I don't know. I'm like, assume that I don't know the answer to the question. That's what I'm asking. So are you answering the question for us? Anybody? What does the E mean? Okay. I can't tell you for a fact, what that provision suggests or what it means. But the understanding we have is that they say there's some constitutional relations and the customary law between chiefs. As to what that means, it's still an exercise in academia. So when I find the answer, I'll share it with you. I've not found it yet. I didn't understand it then. I don't understand it now. When I find the answer, I'll share it with you.
Senior.
Yes.
So if we have a question in relation to the E, how do we know that this is indeed a cause of matter affecting chieftaincy?
This is you're asking me a question that I do not have an answer to. I don't want to give you rat poison so that you won't stand somewhere and say that Telfer said. I do not know.
Okay.
All I know is that it is one of the issues in terms of causes of matter affecting chieftaincy. Please, disclaimer duly given. Excellent. Let's proceed. It must be noted. Richard, yes, please.
All right, thank you. So, in the case of Republic versus Kratchit Traditional Council, Kratchit Traditional Council Judicial Committee, ex parte Anani, the issue of the constitutional relations between chiefs was discussed. The constitutional relations and the customary law between chiefs was discussed. In that case, the applicant, Anani, was installed as a chief in a village called Bejamsi. And then the paramount chief of the Kratchit Traditional Council was supposed to sign for him to be gazetted. The paramount chief refused to sign because, according to him, the Bejamsi chief should have come to swear allegiance to him before he does the signing. And then the Bejamsi chief too decided that he was not going to swear the allegiance, and that the signing of the forms for him to be gazetted was one of a constitutional issue and not was an administrative issue and not one of a tradition. And so he went to court, and then the court actually held that the issue of the swearing of allegiance was one of the relations, the constitutional relations that exist between chiefs. And so such an issue was one that is a cause or matter affecting chieftaincy and not within the jurisdiction of the court. However, on the issue of the signing of the document for the Bejamsi chief to be gazetted was an administrative issue, and for which case the court granted, I think, a mandamus to compel the paramount chief of Kratchit to sign for the Bejamsi chief to be gazetted. So that was the basis for which I said it was the constitutional relation and the customary law between chiefs.
Please share the case with us again. Ex parte. Richard, please share the case with us again. The name of the case.
The name of the case is Republic versus Kratchit Traditional Council Judicial Committee. Kratchit Traditional Council Judicial Committee, ex parte Anani.
Okay.
The citation is 1975. One Ghana law report.
Right. So the case is Republic versus Kratchit Traditional Council Judicial Committee, ex parte Anani, 1975, One Ghana Law Report at 276. Maybe we should all give ourselves assignments and go and look at the case and then determine if it helps us answer that question. Okay, thank you for the contribution. It is much appreciated. The point must be made that it is not sufficient for a party to just indicate that it's a cause or matter affecting chieftaincy if it doesn't fall within the 1 to 5 that we have just discussed, and that the mere incidence of a matter relating to chieftaincy or the involvement of a chief in a matter would not be sufficient to rise to the level of a cause or matter affecting chieftaincy. And so the position of the courts that we must pay attention to is that you must be able to demonstrate that either of the 1 to 5 points that we have raised arises in a course or in a particular set of facts. And that if it doesn't arise, then you cannot merely allege that it's a cause or matter affecting chieftaincy, on which grounds the jurisdiction of the Supreme Court, the jurisdiction of the High Court would be ousted. So you may please see the case of Inri Ogwa Paramount to Gabra versus Central Regional House of Chiefs and Hazel. Inri Ogwa Paramount to Gabra versus Central House of Chiefs and Hazel. And then Inri Osustu Ako Note the second Mankralo Ovusu Note Owu Intervena. Inri Osustu Ako Note the second Mankralo Ovusu Note Owu the who was intervener in that matter. So the mere incidence of an issue relating to chieftaincy in proceedings would not be sufficient to oust the jurisdiction of the High Court simply on account that it relates to a chief or a chief is involved. This is why if you have a land dispute with a chief, you won't say that that is a cause or matter affecting chieftaincy. Please, are we clear?
Yes, please.
So we've conclusively dealt with matters that are out of the jurisdiction of the High Court, especially in relation to chieftaincy matters. But it is not correct to say, and I've made this point several times, that in all instances, the High Court will not have any jurisdiction over a chieftaincy matter. Like we've mentioned, when we were doing judicial review last week, the High Court and the Supreme Court retain what is known as a supervisory jurisdiction over all lower courts and tribunals. And this supervisory jurisdiction also extends to the chieftaincy tribunals. The Court of Appeal in Toba and Kwekuma, like I mentioned earlier, noted that the supervisory powers of the High Court by way of the common law writs, which we discussed last week, is distinguishable or is different from the ban placed on the exercise of original jurisdiction by the High Court in chieftaincy matters. So the High Court will continue to enjoy its review jurisdiction, and that review jurisdiction is exercisable over the chieftaincy tribunals, and same was affirmed in the case of ex parte Bediako II. So Republic versus High Court Koforidua, ex parte Bediako II is good authority for the supervisory jurisdiction of the High Court in relation to chieftaincy tribunals. Does the High Court have supervisory jurisdiction over the National House of Chiefs Judicial Committee? Question: does the High Court have jurisdiction over the Judicial Committee of the National House of Chiefs?
Yes, I think so.
Why?
Because it has the supervisory jurisdiction for all lower courts, which includes the traditional council.
No, so my question is the Judicial Committee of the National House.
The National House.
Yes.
Yes. It's also a lower court.
Any other opinions? Richard, yes.
To my mind, I think that since appeals from the Judicial Committee of the National House of Chiefs lies to the Supreme Court, and the Supreme Court is equally sized with the prerogative writs to as it is control lower courts and administrative bodies. In the instance, I think that when it comes to the supervisory jurisdiction of the National House of Chiefs, that jurisdiction will ordinarily not be within the confines of the jurisdiction of the High Court, but the Supreme Court. This is just an opinion. I don't have any authority to support it, please.
Okay, thank you for your opinion.
I think where is it the practice direction for 1981 or so, where the High Court and the Supreme Court has concurrent supervisory jurisdiction, it is the High Court that will suffice. That's
Okay.
my.
Please go. And okay. Anybody else? Yes, when the High Court shares, it's not just supervisory jurisdiction, any form of jurisdiction with, or when the lower court shares any form of jurisdiction with the superior court, it is that lower court that you must first defer to. I do not see any provision in law that prevents the High Court from exercising its supervisory jurisdiction over the National House of Chiefs. And so, yes, that is that the High Court exercises that supervisory jurisdiction. And as you are aware, the High Court has a party may apply to the High Court for an order in respect of the prerogative rights to prevent the occurrence of an event. Of course, if the matter that has arisen would invoke in terms of the judicial review considerations of the court. When that happens, the party is at liberty to apply to the High Court to have any remedy which may be within the contemplation of the prerogative rights. And then the High Court will have jurisdiction in that instance. Any questions? Great. They are also, the Supreme Court has also clarified in two matters that when the substance of an action is in effect a chieftaincy matter and it is clothed with, or it is made to appear as though it's a constitutional matter or it's a matter that requires constitutional interpretation, the High Court will decline that invitation. You may see the case of Yadom and Aminyampong. Remember that the Supreme Court has exclusive original jurisdiction in all matters relating to interpretation and enforcement of the Constitution. And in that case, what the plaintiff attempted to do was to couch the matter in such a way that it was a constitutional issue, but it related to a declaration or a claim that would have led to a declaration that the defendant ceased to be a paramount chief by operation of law. And in that instance, the Supreme Court noted that we must look at the substance of the reliefs claimed to determine if indeed the court would have jurisdiction. So where the lawyers of the plaintiff have so fancifully couched the relief to make it appear as though it's a constitutional matter, but really it is a matter revolving around causes or matters affecting chieftaincy, then the Supreme Court would decline such an invitation. And so as much as possible, the courts have tried to guard and protect the jurisdiction that the Chieftaincy Act and the Court Act have granted to the chieftaincy tribunals. Excellent. Final part. Is a chieftaincy dispute arbitrable? Question. Is a chieftaincy dispute arbitrable? You are experts in alternative dispute resolution.
I think yes, because is it section 30? They have the customary arbitration, right? I'm off my head.
But customary arbitration, is it related? Can a customary arbitration be used to settle a cause or matter affecting chieftaincy?
In fact, I know by Section 30 of the Chieftaincy Act, it says something like that, but I'm not too sure. I stand to be corrected.
What do we think? Just think about it. Your answer doesn't have to be right. I want a discussion on what your position is. Do you think a chieftaincy dispute is arbitrable? No opinions.
I think it is.
Okay.
If we look at Section 1 of the Arbitration Act, Alternative Disputes Resolution Act, it lists the matters that ADR cannot be used to settle, and it makes mention of 4. And it doesn't really state chieftaincy matters or matters or causes affecting chieftaincy. And I'm also thinking it is because, if you look at the proper sense of the word, these judicial committees, how are they really resolving these issues? If not the use of ADR, then I don't know how they are going about it. Because it's not like they follow any laid down procedure in dissolving the matters. So I think they actually use these ADR processes to deal with the matters that come before them. And if Section 1 does not of the ADR Act does not also expressly say that they cannot be matters for which arbitration can deal with, then I don't know why, or I don't know of any law that says the negative, that chieftaincy matters are not arbitrable. I think they are arbitrable.
Okay. Any other views? I'll take one last one. So, I'll share 2 decisions with you, and then you can look at them, and then we can come to a determination as to whether or not a cause or matter affecting chieftaincy can be arbitrable. The first case, let me mention the cases for you. Republic versus Adan Traditional Council, ex-party Patrick Agude Tay, and others. Republic versus Adan Traditional Council, ex-party Agude Tay, and others. Please, did you get the case?
Yes, please.
And then there's Inri matter of Obapenyin Amamansa and others. Inri matter of Obapenyin Amamansa and others. And Nanaya Educhumwa and 7 others. Matter of Obapenyin Amamansa and others. And Nanaya Educhumwa and others. So the position taken in that case is that, first of all, like Jody mentioned, the ADR Act clearly outlines provisions or instances where ADR will not be acceptable. So, for instance, Section 1 indicates that if it is a matter relating to the national or public interest, the environment, enforcement, and interpretation of the Constitution, or any other matter that by law cannot be settled by an ADR method, then it may be arbitrated upon, or it may be a matter that may be submitted to ADR. That's the position outlined by Section 1 of the ADR Act. And the Court of Appeal was of the view that the ADR Act, so the Court of Appeal in the Agudate matter noted that the ADR Act had expressly provided for matters to which the Act does not apply. And the Part 3 of the Act makes provision for and deals with customary arbitration. And so the court was of the view that matters bordering of chieftaincy may also be subject to arbitral proceedings. And so this was an affirmation of the position taken by the High Court judge, which outlined that in light of the ADR Act, it is not only the judicial committees of the Traditional Council, Regional House of Chiefs, or National House that can have jurisdiction over chieftaincy matters, but if the parties voluntarily submit their disputes to arbitration, then it can be a cause. So then, in that instance, a cause or matter affecting chieftaincy can be subject to an arbitration proceeding. I do not agree with that decision. My view is that Section 57 Court Act, Section 76, 117, and our and generally the jurisdiction of the various tribunals in relation to causes or matters affecting chieftaincy is that it does not appear as though the lawmaker in making the ADR Act, especially in matters relating to customary arbitration, intended that causes or matters affecting chieftaincy should come under the ambit of customary arbitration. And that, in my view, our understanding of the exclusive jurisdiction of the chieftaincy tribunal still persists, despite the ADR Act. And I mean, even in the Obapeni and Amamansa case, which is a Supreme Court decision, it was not authoritatively stated that the ADR Act may apply or can be used in a chieftaincy proceeding. So, I mean, that's my view. It doesn't mean the current position of the law is what has been affirmed in the Court of Appeal decision, ex parte, Richard Agudete. And so go for that. But you may also explore the law and read the case and see if you are you're in agreement with the position taken by the court. I wonder if in the future, when this matter arises again before the Supreme Court, they may reconsider the position taken by the Court of Appeal. So yes, simply put, just so nobody's confused, our understanding is that the chieftaincy dispute is arbitrable, and that when the parties voluntarily submit their dispute to arbitration within the contemplation of Act 792, same can be validly adjudicated upon, and the decision of that arbitration or that alternative dispute resolution process will be binding on the parties. Any questions, please? Great. That concludes our staff clauses. Thank you for indulging me, and I hope you found this useful. And yeah, I look forward to seeing you next time.
Thank you.
Thank you.
Thank you. Thank you. Well done.